Okay. So good afternoon, everyone. Thanks for joining us on our webinar series today. I'm Kathy Jancy, if you don't know me. I'm a senior research attorney here with the National Sea Grant Law Center. In today's presentation, I'm going to cover some of our more recent mariculture work, and in particular, focus on a lot of our seaweed work. So just a few quick housekeeping notes before we begin. We do have everyone on mute right now to cut down on background noise. So feel free to use the chat box at any time if you have a question. We should have plenty of time for question and answer at the end of the webinar, but we can also try to answer questions as we go along if they come in. If you have a technical issue, you can private chat with Lauren Freeman, who is the National Sea Grant Law Center's project coordinator and our webinar host. And then I also wanted to let you know that we are recording this webinar and we're going to post it to our website as soon as we can after the webinar. That usually takes a couple of days to get the transcripts and captions and everything finalized, but be on the lookout for an email about that for when it's up on our website. So for those of you who aren't as familiar with the National Sea Grant Law Center, we were founded in 2002. We are housed at the University of Mississippi School of Law, and our mission is to conduct legal research, education, and outreach for the wider Sea Grant network of 34 Sea Grant programs and their stakeholders. If you are interested in our work and what else we do and have going on, I encourage you to visit our website and to also follow us on social media. But now I want to get to the topic of our webinar today. And so I wanted to cover today some of our recent mariculture projects as I discussed. And so first, I'm going to talk about some of the state seaweed regulatory review that we've been doing this summer, as well as looking at the federal nationwide mariculture permits. And then finally, I will give us an update on some of our seaweed food safety projects and some of our recent materials that can be of use. So, wrong way. So first, we've been working this summer with a law student on doing a review on state seaweed permitting. And so our review covered Alaska, California, Connecticut, Hawaii, Maine, Massachusetts, New Hampshire, New York, Oregon, Rhode Island, and Washington. We have shared drafts of those reviews with Sea Grant agents in those states, and they've been providing us feedback on them. And so we hope to have those finalized in the next month and posted on our website. In that review, we had a particular focus on the types of authorizations that were needed, the length of the authorization, so how long it will last, as well as the fees that were associated with it, as well as what state restrictions there are on sourcing stock. I just wanted to note here, in case I say any of these things in the webinar, lawyers are not scientists, and usually legislatures are not scientists. And so sometimes these laws and regulations are using the phrase marine plant or aquatic plant to refer to macroalgae. I know a lot of you are particular that it is not a plant. So if I use that term, just know I'm using the term that the state is actually using in their law and regulation, and noting that that is not necessarily the correct scientific term for what we're talking about. So I'm sure this is not a surprise to anyone who works in this area or in aquaculture in general. But this is a complicated process. And as we were going through each state, we noted that every state is going to need multiple authorizations to be able to get a seaweed operation up and running. Part of that stems from the fact that we are in the water, which is often publicly owned lands. And so you're going to need the approval from the state to use that property. Some states also have tribal land that you'll need to get approval of. In particular, Washington notes that they have a lot of tribal land where they might have to get that approval as well. And then in addition to actually being able to use that land, they're going to have to get any number of operational approvals to be able to get up and running. This is going to be a combination of permits, licenses, leases, and etc. Those terms change from state to state. I will note that licenses in particular is an interesting word because at least 2 states, Maine and Oregon, actually use the term license in regards to being able to use publicly owned lands. And then a lot of states use that same term for the operational approvals. So we really do have to be particular about what term is being used in each state and for what. And as I kind of alluded to already, you're going to need approvals from federal, state, maybe tribal, county, and/or local governments in trying to get these operations up and running. So I'm sharing this map, not because I think you'll be able to read it. I recognize it's probably too small on your screen, but I do want you to know, a couple different things that's going on here. One, this is obviously a very complicated chart showing all the different permitting steps that are needed in Alaska. On the left-hand side, I just want you to note all the different agencies or entities that need to be involved in this process. So on the federal level, we're showing the Army Corps of Engineers, U.S. Fish and Wildlife Service, National Marine Fisheries Service. On the state level, the Environmental Agency, Fish and Game Agency, the Natural Resources Agency, and then also highlighting the local government. And then I also want to highlight, while this is kind of an overwhelming chart, to also note that it's Alaska, which is the state, one of the states with the most robust seaweed industry right now. And so while this process can seem overwhelming, it's definitely one that people have gotten through. And I think that should be encouraging. And part of the reason we're trying to put together these kind of state by state reviews of what is needed to be able to help people know what agencies they're supposed to go to and kind of what they're looking at when they're getting started in this process. And then also noting that this is from the state of Alaska's website. And so the state themselves may be trying to be helpful in helping potential growers get through this regulatory process. So I also wanted to highlight some trends we saw among the different states when it comes to sourcing seaweed stock. And so some states are requiring that the seaweed come from in-state. Some are saying it just has to be a native species. And for those states that are allowing stock to come in from out of state, they may be regulating that importation of the stock itself. So I just wanted to share some examples of what we've seen. So Maine, for example, is one of the states that's saying we have to have the seaweed come from in-state. They say all seaweed shall be obtained or cultured from stock originating in Maine coastal waters. Connecticut says you cannot use kelp source tissue from outside Long Island Sound, except in waters to the southern land point of Rhode Island or Massachusetts. And then Alaska in particular, the regulators have termed this a genetic precautionary approach. They say that the parent stock has to come from within 50 kilometers of the farm site. So being very cautious about where it's coming from to protect both kind of the genetic makeup of the native seaweed that's there, as well as trying to keep out different diseases that can be coming in if the stock came from further away. Other states require native species. So Rhode Island says you can't get an aquaculture license for species that are not endemic to the state without prior approval for the state. And so they do have a process maybe for authorizing that, but their base statement is you're going to have to use something that's native. New York's permits reference, growing native algae to New York. And as I said earlier, that provision usually comes with a follow-up that says, if you're going to import the macroalgae into the state, you need a separate importation permit. And so in the states that are allowing the sourcing from out of state, that's very common to see. And then finally, I just on this point wanted to highlight Washington because they do have an importation provision in their laws and regulation. So they say you can import kelp or other seaweeds if you get an import permit. But currently, they're not approving any out-of-state seaweed or kelp hatcheries to import into the state. So they're requiring all seed to come from an in-state facility. So I just wanted to highlight this one because on the books, in the laws and regulation, there is this provision that's saying they will allow importation. But in reality, right now, they haven't approved any place to get that from. And so in essence, in Washington, if you wanted to start growing, you'd have to get it from somewhere inside the state of Washington. Okay, so the second project we worked on this summer was to look at a review of the federal Army Corps permits that we see in aquaculture activities. And so for those of you who don't know, the Corps is authorized to issue permits under both Section 10 of the Rivers and Harbors Act and Section 404 of the Clean Water Act. Section 10 is requiring permits for what we call structures. So in a mariculture operation, you would think of that as the cage, the nets, the racks, lines, etc. That would be in the navigable waters of the United States. While the Clean Water Act Section 404 would be for any dredge and fill activities that were happening with the project. The Corps has taken the position that a lot of normal day-to-day aquaculture activities actually don't qualify for dredge and fill, but they have given examples from when that Section 404 could come into play. And so, I'm happy to follow up. That's kind of a nitty-gritty kind of rabbit hole to go down, but I'm happy to follow up with anyone who has specific questions about that. But generally, they say it's not involved. So the Corps authorizes those permits under both Section 404 and Section 10. And so those permits can be either individual or general permits. General permits are authorized at the state, regional, or nationwide level for any category of activities which are similar in nature and will have only minimal adverse environmental effects, both individually and cumulatively. Individual permits, on the other hand, may be issued for projects which do not meet the criteria of a general permit and are often those which they have more significant impact on the environment. So a nationwide permit is a type of a general permit that authorizes the activities across the country. It's important to note that despite its name, a nationwide permit may not apply everywhere in the country. So the core 38 districts implement the regulatory program for each nationwide permit. So the use of the general permits is not uniform throughout the districts. That said, the vast majority of permitting is done through nationwide permits. Partly that's because the approval process for nationwide permits is very streamlined compared to other permit types. In exchange for that easier process, again, the nationwide permits are only supposed to be used for these projects that are having these minimal adverse impacts. Nationwide permits can have any number of general terms and conditions set by the Corps, and then certain regions can impose additional conditions which projects in that region must follow, as well as continuing to abide by whatever national conditions are set. And so when examining a particular project, the district engineers or the Corps representatives who make the on-the-ground permit decisions have the authority to attach individual conditions which the project must also meet to retain eligibility. And I'm happy to say that we're soon going to be posting a memo that kind of covers an overview of everything I just said, to hopefully be able to provide kind of an easy overview of what we're really looking at when we're talking about, in particular, Army Corps permits, and kind of how each one kind of works. In particular, we wanted to talk about today about the 3 mariculture permits. So each of these were issued in 2021. For nationwide permit 48, that was a reissuance of the permit. But for the first time in 2021, we saw nationwide permit 55 and nationwide permit 56. Those were both a direct result of an executive order, which told the Secretary of the Army to begin the development of permits for seaweed and finfish aquaculture, which eventually became 55 and 56. And so when I was originally working with my student, we were working on seaweed issues, and we really wanted to see, I wanted to see kind of what the status was with nationwide permit 55 in particular, and kind of where it had been adopted throughout the country. But as we were looking at the different permits, we decided to take kind of a closer look just to see where we were with nationwide permit 48 as well as permit 56. And in particular, we flagged nationwide permit 56 just because it is the subject of current litigation, which I'll talk about, and we wanted to kind of see how that might affect the renewal process for these 3 permits, and in particular, nationwide permit 55. Some of you may remember that the previous version of nationwide permit 48 had quite a bit of litigation, which eventually resulted in it being suspended in Washington. And so I'll reference that litigation in a little bit when we talk about the current permit 56 litigation, because they're pretty similar. So our student prepared for us this map looking at kind of the current status of the permits throughout the country. So it's green is showing that all 3 are approved, all 3 mariculture permits. The yellow is showing conditional approval, like I mentioned, with some conditions on it. And then the red in particular is showing suspended. In New England, there are no nationwide permits, and so that's why they are all showing up as red. The district doesn't use them, but each of them have a state level general permit that they're using in its place. So I was, kind of surprised when I saw this, just to see how wide the approval process was in the regions. Because again, I was just curious to see where we were with the different nationwide permits and how they've been implemented throughout the country at this time. Now, nationwide 56 is the subject of current ongoing litigation. And so our summer student, Colin Dowson, he actually did a blog post on this. I have the QR link if you kind of want more information about the litigation itself and some more background information. But this lawsuit was filed pretty soon after the nationwide permit was finalized. And so a group of environmental groups, including Don't Cage Our Oceans, filed suit claiming that the course issuance of the permit and saying that the finfish nationwide permit would only have a minimal adverse environmental impact was arbitrary and capricious, and that the permit should be set aside as unlawful. Now, the plaintiff's arguments here really similarly track the same arguments that they made in that nationwide permit 48 shellfish litigation from a few years ago. And so they're saying the conclusions that there was minimal impact was not supported by the record. In particular, they argue that the record itself wasn't robust enough. They then add that the potential impacts were not analyzed correctly. They were poorly analyzed. They didn't, analyze enough impacts. And then they've made this similar argument, which was successful with the nationwide permit 48 litigation, where they said that the nationwide permit punts too much discretion to the district engineers. And so these were all arguments that were successful in that nationwide 48 litigation. What could make this case different than that nationwide 48 litigation? The court has brought up both of these points. That first, that this is a new nationwide permit and not a reissuance. And so on the point of saying that the record is not robust enough, they say they have less information about potential impacts because it hasn't been done before. So while with the shellfish nationwide permit, they could look at to kind of see what has happened in the past, they don't have the benefit of that with the finfish permit. And then they say, even though they have less information, they actually did a more thorough analysis. They said they did a better job than they did with Nationwide 48. And they say that the district engineers are merely there to cement decisions that they had already made at the national level. And so the Corps is making kind of a strong effort to try to distinguish the two lawsuits, especially because the legal arguments are so similar brought by the plaintiffs. This is ongoing litigation. They just had oral arguments in the beginning of July. I just checked the docket this morning. Nothing new has come up. So this is definitely a lawsuit that we're tracking, and we will keep the network posted as we see kind of how the litigation goes forward from here. But again, we were really interested to track this one just to see how it might impact the reissuance of all 3 permits in the future, since they are coming up to be reissued in the future, including the nationwide permit for seaweed. And then finally, I just wanted to touch on some of our recent seaweed food safety work and some of the products that we have put out. We've been working on this. It originated with our advisory service for sea grant programs. And so through that service, sea grant programs are able to come ask the Law Center discrete legal questions that they have. I'll direct you to our website if you're not familiar with our advisory service, just because this is a good example of how our advisory service kind of transformed from one discrete question into bigger projects that we've continued to work on for several years now. But the initial question we got asked from Connecticut Sea Grant was how raw seaweed would be regulated under the federal food safety regime. And so for those of you who aren't as familiar with this topic, all food in the United States is regulated under the Federal Food, Drug, and Cosmetic Act, known as the FDCA. And there's a general prohibition that any food cannot move in interstate commerce if that food is adulterated or misbranded. And so that means it can't be prepared, packed, held under unsanitary conditions. And so in the United States and even abroad, we have these couple different ways where we try to keep food from becoming adulterated. And so a lot of people on this call will probably be most familiar with the use of seafood HACCP, but HACCP's also used for juice, dairy, and meat and poultry. And then another alternative to use would be a food safety plan. And so that question we got from Connecticut Sea Grant was pointing out that the state had decided to use HACCP for the seaweed in the state. But they were curious about what the alternative would be under the Food Safety Modernization Act. And so FSMA, as it's called, is a newer food safety law, but it only applies to food facilities. And so a food facility is anyone who's engaged in manufacturing, processing, packing, or holding food for consumption. And then I'm highlighting here just what it means to manufacture or process. So that's making food from one or more ingredients, or synthesizing, preparing, treating, modifying, or manipulating food, including food crops or ingredients. And in particular, I've highlighted there that an example for that could be drying or dehydrating. And so we've gotten a lot of questions, one, thinking just about raw seaweed, but then a lot of growers are also drying and dehydrating to try to extend either the shelf life or be able to ship it. So the question, we initially were tackling, and then as I'll talk about, we've kind of evolved it with different products we've created, is just this question of where does seaweed fit in this regulatory structure? And so seaweed, the FDA has made a statement that it's a raw agricultural commodity. That statement's probably a few years old at this point. When we started working on this, we didn't even have that from the FDA. But that means a couple different things. So first, it means that raw seaweed is exempt from the requirements of FSMA. And so it only has to comply with the general requirements of the Food, Drug, and Cosmetic Act, and in particular, that adulteration provision. It means that processed seaweed is a facility, and that those operations have to comply with FSMA, and in particular, the hazard analysis and preventive control rules. And then what's been interesting, and we've been looking at even more closely recently, is this drying dehydration piece, because we continue to get questions about how that exemption works. So the farm definition says that drying and dehydrating seaweed is exempt from FSMA if it happens on the farm. We followed up with FDA recently, and I asked them a couple of very specific questions. So I asked one, is there a time requirement for when that drying and dehydration has to happen? And they said no, as long as it happens on the farm, it's covered. I asked if there was a difference between drying and dehydration because they're technically different processing, and they said no, there is no distinction between the two. And then in particular, the farm definition also breaks out a farm to both the farm itself and then what they call a secondary purpose farm, which is if there's a facility that's also owned by the same entity, that drying and dehydration can potentially happen there and still be covered. So this drying dehydration piece is a piece we're working on, and again, we're going to be putting out kind of a one-pager or two-pager, kind of going over everything I just said, just because that's a piece that we continually to get questions about, kind of how that exemption works. The other exemption to point out is that under FSMA, there's an exemption for what's called a qualified facility. And so what that means is if a business is averaging less than $1 million per year in sales, they're exempt from most requirements under FSMA. And so that is including a lot of facilities in the United States that are growing, I should say operations, not facilities, that are growing seaweed. So the first step that we've done to kind of address a lot of these legal issues that we got is to create this series of infographics, which are available on our website, that are kind of breaking down kind of all those legal issues I covered probably too quickly just then about how kind of FSMA and the FDCA are working together. So we have an infographic that looks at kind of how FDA is classifying seaweed and what it means to be a raw agricultural commodity. The other thing to note on that piece is we get a lot of questions about whether seaweed is actually covered by the produce safety rule, which has been issued under FSMA, and it's not. The actual comments to the produce safety rule specifically say that algae was considered and was not covered. So we cover all of that in that first infographic. Second infographic looks more particular at kind of that exemption for being a qualified facility that I just talked about. And then our third one, we got a lot of questions, also what it means to just mean for a food to be adulterated. So we created an infographic that gives an overview of kind of what it means to say what's being adulterated food, specifically because so many seaweed operations are just being covered by the FDCA adulteration provision. Then we were left with this lingering question, because one, we're looking at most seaweed operations being exempt, either through that farm definition or the $1 million cap. And then, as I mentioned, kind of alluded to earlier, so many seaweed operations are actually, that are exempt, are being required to use HACCP on the state level. And so it left us with this question of, okay, what happens if an exempt seaweed operation that's currently regulated under HACCP loses that exemption for, a number of reasons, and they're going to have to transition to FSMA. And so this was a question that bubbled up through the Seaweed Hub regulations work group with the law, which the Law Center were the facilitators from. And so we worked through the Seaweed Hub with New York and Connecticut Sea Grant, in particular Mike Ciamarella and Anish Concepcion on this seaweed food safety document that is comparing that preventive controls for human food rules with seafood HACCP. And so the document itself is a very good background document, and was one of the reasons I wanted to highlight it, because it features an overview of FSMA and what's required under the law. It gives a good background of that qualified facility exemption, as well as the farm definition. So more background on kind of what is covered and what is not covered for seaweed operation. It compares the HACCP program with the preventive control for human foods piece. And then at the end, Mike put together a very good checklist for operations to go through if they're transitioning from HACCP to the preventive control rule. And so it's a really good document for people who are doing that transition. But again, it also has a lot of very good background information if you want more background on kind of those issues I talked about just briefly here today in our webinar. The document also has some interactive features. And so one of the things we recognized was that there's a lot of technical and legal terms used here. And so every time one of those terms that is used in the regulations and that has a regulatory definition, we made pop-ups for those definitions. So if you couldn't quite remember what it means to be a very small business or to be a qualified facility, you could just hover over the word and the definition would pop up, and you don't have to go back to the definition section to see kind of what that term means. And then likewise, we have links within the document for additional sources. So this example I'm showing here is actually, there's a link for adulterated food to that infographic. I highlight it, as well as there's links to the regulations themselves and some other background information documents that either the team or other states have made. So there's a lot of good resources in the document itself to actually point you to other places to get more information on this topic. And then just another piece of what we've worked on with the seaweed food safety piece in particular was we've continually gotten questions and concerns about being able to write state level seaweed food regulations because the science and the understanding of food safety hazards with seaweed is still kind of developing. And so we worked with UMass Boston to create this peer-reviewed journal article database. Some of you might have heard us talk about it before, but I just wanted to remind people that we have it. And the way the platform works is you are able to kind of narrow down the articles that are in the database. So you can search by species of seaweed, the year of the article, specific keywords, and in particular, if there's a particular contaminant or issue that you're concerned with, you can search by whether or not the paper thinks it's a low hazard, moderate hazard, major hazard. And then that list of papers below will populate with the ones specifically related to whatever search topic you had, as well as that map over there will kind of populate showing you where in the world that article is coming from. Because a lot of the other comments we've gotten is, that the industry is so much further along in other places and what's happening there. The other thing I will note is that there is a Google form on the page. to submit articles that aren't in there. And so definitely reach out to us too, if you think there's something missing from there. Because we want this to kind of be a helpful website for people working on this topic. And then finally, I just wanted to highlight some next steps that we're working on. So we're in a project led by New York Sea Grant. It was USDA funding. And the goal of that project is to develop a seaweed hazards and control guide for going for the seaweed industry on potential food safety hazards. And we thought that that was a crucial next step to develop a guide so that we could eventually lead to a seaweed specific food safety training program for the food safety industry. So that project's ongoing. And so we will definitely keep you posted when we finally get that guide published. But again, we're just in the middle of the drafting process. And so we won't have that for another year or so. So with that, I will wrap up and we can move to the question and answer portion. But before we do that, I just wanted to, say again that this webinar is going to be recorded. And so we will be emailing you as soon as it is up. And I will stop sharing my screen. Quickly, that's my contact information if you want to reach out to me in particular on any of these questions. And I'm always happy to talk about, in particular, seaweed and aquaculture in general. It's one of my favorite things to work on. So I will stop my share and we can see if there's any questions.
Yeah, Kathy, it looks like there's one question in the chat. Is there any form of regulation or guidance for macroalgae extracts made in the United States?
There's regulations for it being used as an additive for certain seaweeds. I'd have to double check before I say anything definitive on that extract piece. But the additive ones are the only ones that are coming to my mind. And Amalia, I see your comment that the geographic restrictions on sourcing are not necessarily based on understanding population genetic. I know you guys have been working a lot on that topic. So yeah, valid point. Okay, see no other questions. Thank you again for tuning in. Our next webinar is going to be on September 17th at the same time on the U.S. Supreme Court term and the cases that are relevant to the Sea Grant Network. But again, thanks everyone for joining, and we'll let you know when the recording's ready to be posted.